Lordship indulgence in making a mention of item number 10, hearing list. Your Lordship, it appears that Mr. Benjamin Lal Thamona, who is for the state, is on medical leave. So it appears that it will not be, today might not be possible for hearing.
You're for the petitioner.
Yes, my
You're mentioning on his behalf.
state.
This case is being handled by Mr. Benjamin, and he's on medical leave.
Item 10, you right? Mr. Benjamin Lal Thamona, learned government advocate, who is handling the matter, is on medical leave. Stop on a mention made on his behalf. Matter stands adjourned for 2 weeks. Yes.
Oblige.
Any more mention?
Motion, item 1.
May I please your lordship?
Yes.
My lord, this matter pertains to the petitioner's claim for the family pension of her late mother, who during her lifetime had worked as a Safai Wala at All India Radio, Aizawl, and she retired in the year 1996. And she had been receiving pension till the time of her death in 2017. And the pension was discontinued thereafter. The petitioner, being the widowed daughter of her late mother, she is entitled to the family pension as per Rule 54, Sub Rule 6, Clause 3 of CCS Central Civil Services Pension Rules 1972. And claim application in Form 14 for family pension was submitted by the petitioner, which was forwarded by the respondent number 5 director, All India Radio, to the respondent number 4, Pay and Accounts Officer, Kolkata. And her entitlement was not disputed by the respondents. And the petitioner was then requested to submit the old PPO books through letter dated 19/8/2021, and thereafter Annexure 10. And the old PP books was submitted by the petitioner, but there has been no communication till date.
That was in 21.
Yes, my lord.
We're in 25 now. So for almost 4 years, you were doing nothing.
My lord, we have gone to the office of the respondent number 5 countless of times, but we were always told to come back at a later date.
Earlier, you had filed a writ petition, isn't it?
Yes, my lord.
Why was it withdrawn?
There was some defects in the petition, my lord.
Petitioner is what? The unmarried daughter or the
She's the widowed daughter.
widowed daughter?
Yes, my lord.
What is that provision? Under which she is entitled to pension?
Rule 54, Sub Rule 6, Clause 3.
Have you mentioned that anywhere in your writ petition?
Yes, my lord.
Where?
Para 6, my lord.
So this is basically Rule 54. We're talking about sub-rule and all
Sub
that.
Rule 6, Clause 3.
Sub-rule 6 and clause 3 you have not mentioned anywhere.
But my lord, this was not disputed by the respondents.
That's another thing. Not disputed is another thing. But you're claiming under what? Then why do you mention Article 226 then? If it's not disputed? Give me CCS. What is that?
I have not been given the pension till date.
What? Compilation. CCS Rule 54.
Sub Rule 6, Clause 3, my lord.
Sub Rule 6, Clause 3.
Clause 3, yes, my lord.
You have a copy of the book?
Yes, my lord.
Show me. The High Court rules permit print of the petition in both sides, but it's preferable if it's only one side is printed because it's not convenient.
Yes, my lord.
See, your petition is not even bulky also, it's only a few pages. Rule 54,
Sub Rule 6, Clause 3.
Sub Rule 6. You are the widowed daughter.
Yes, my lord.
Your mother expired. When did she expire?
2017. March of 2017. Annexure 5 is the death certificate.
15 March 2017.
Yes, my lord.
Then when did you start claiming?
2018, my lord.
Where is any document to that effect?
Annexure 9, 8 and 9.
Please write down card. Miss, your good name?
Vanal Monpui.
Vanal Monpui, learned counsel for the petitioner, who submits that the petitioner is the widowed daughter of Srimati Kaveli, an ex-Safai Wala working in the All India Radio ISO. Stop. Srimati Kaveli retired on 1/5/1996 and she was paid pension with PPO number 284-389-600-439 till her death on 15/3/2017. Stop. The petitioner therefore submitted her claim for family pension to the respondent authorities. Soon after the death of her mother. Stop accordingly. The director bracket ENGG close bracket and head of office All India Radio Izone bracket respondent number 5 close bracket forwarded her application for family pension in form number 14 to the Pay and Accounts Officer, Pension Section, All India Radio, Kolkata. Bracket respondent number 4 on 26/11/2018. Stop thereafter, the petitioner was asked to submit the PPO book issued to her mother for further necessary action. Stop, the petitioner submitted the same and which was forwarded to the respondent number 3 on 19/8/2021 for necessary action. Stop, however, till date, since family pension has not been given to the petitioner, the petitioner having no alternative is before this court. Stop, the learned counsel for the petitioner submits that the petitioner is entitled to get family pension in terms of Rule 54, bracket 6, bracket small Roman 3 of the CCS pension rules. Pension will be within bracket. Comma 1972. Stop, next para. In view of above, issue notice of motion returnable by 4 weeks. Ms. Adam Sangpuri, learned CGC, accepts notice on behalf of
All respondent, my lord. Respondent number 1 to 5.
all the respondents, and therefore no formal notice is required. Stop, petitioner shall however furnish requisite copies of the writ petition to the learned CGC, if not already done. List the matter again after 4 weeks.
Orders, item 9.
Lordship, I am appearing for the sole respondent, and I will be filing my affidavit in position this week, my lord. The registrar, Firms and Societies, is out of station. He will be back by today.
When you will file?
Within this week, my lord.
Ms. Caroline Kelung, learned counsel for the sole respondent, submits that she will be able to file the counter affidavit of the respondent within the course of this week. We'll stop, in view of above, list this matter again after a week.
Right.
Then one more line, Mr. Johnny L. Tocho, learned counsel, appears for the petitioner. Yes.
Admission, item 2.
May it please your Lordship.
Yes.
Lordship, I appear for the petitioner in this matter. Lordship, I pray for some time to file a reply to the additional affidavit filed by the respondents. Your Lordship.
What is there to reply?
Lordship, they have filed a reply to our amended writ petition, Your Lordship. So it's regarding those two additional annexures that we have annexed in the new amended writ petition, Your Lordship. So short date may be given, Your Lordship. We will file a reply.
Which affidavit is that which you want to reply? Filed on?
Filed on, Your Lordship.
Filed by whom?
Filed by respondent numbers 1 to 3, Your Lordship. There's an additional affidavit, Your Lordship.
When was it filed? This year or last year?
This year, Your Lordship.
This year. See, your case, your writ petition or your case is getting voluminous. Documents after documents are being filed. I think you should hear this matter one of these days. There is no such affidavit filed this year.
It was filed last
Okay,
year, ma'am.
yes, this is the one.
Perhaps
21st
it is
February,
complete.
additional affidavit filed by the respondents
Lordship.
in response to the amended writ petition.
Lordship.
So you want to counter this also?
Lordship.
How much time?
If your Lordship may give us a short date, if my Lordship may fix the matter on 27th of May, Your Lordship.
Mr. Barua?
Yes, my lord, I've asked specifically.
Uh, Counsel for the petitioner submits that she may be granted 2 weeks' time to file additional counter affidavit to the additional affidavit filed by the respondents on 21/2/2025. First up, the learned counsels for the parties appear through VC. Stop as agreed to. Let the matter be listed on. What was the date?
27th of May, Your Lordship.
27th of May, 2025. The petitioner shall file their additional counter affidavit on or before 23rd of May with a copy to the other side.
Obliged. There's an interim order, Your Lordship.
Interim order passed earlier shall continue.
Obliged. Highly obliged.
Item 3.
Yes.
May it please your lordship. My lord, this is an application for claim of compassionate allowance under Rule 41 of CCS pension rules and encashment of unutilized earned leave under Rule 39, Clause 6A, Subclause 1 of CCS leave rules 1972.
Just a minute. Number one is what? What is the benefit? Claim for?
Compassionate allowance under Rule 41 of CCS pension rules.
Ms. Linda, are you ready? Compassionate allowance. Under rule
Rule 41
of the
CCS pension rules 1972.
and number two?
And the second is encashment of unutilized earned leave.
Yes.
Under Rule 39, bracket 6, bracket A, bracket 1.
Small a
Yes, small a.
and one is number one or Roman one.
Yes, Roman 1.
Small Roman one.
Small Roman 1, yes.
Okay.
And that is under CCS leave rules 1972.
What are you serving as?
Initially, my lord, the petitioner was appointed to the post of LDC, and he
Where?
was promoted in 1976, my lord.
No, in which department?
Annexure 6, my lord, it's in Annexure 6. Department of Supply and Transport.
Supply and transport.
Supply
Okay.
and Transport.
Then?
And he was given quasi-permanent appointment on 20th March 1979.
Hmm.
That is in Annexure 7.
Page number?
Page number 67.
Okay.
And he was promoted to UDC on 25/11/1982. Annexure 8, page 68.
Okay. Then?
And he was regularized as UDC in 1983, 10 March 1983. Annexure 9, page 69.
Okay. Then?
And he was convicted under section 302. The judgment and order is dated 19/12/2012.
19/12/2012.
2012, yes. And
302.
302.
Okay. Then?
Due to the offense that he committed, he was suspended in 15/2/2007 by the Secretary to the Government of Mizoram.
15/2/2007.
2007, my lords. That is in Annexure 1, page 42.
Then?
And he was reinstated on 10/6/2008.
2008.
2008. That is in Annexure 2, page 43.
He was suspended for what? For being arrested?
For being arrested, my lord. And
24 hours.
my lord,
Arrested and being kept in custody beyond 24 hours.
that, no, my lord, it's been quite a while because more than a year it's been more than a year that he was suspended.
No, the reason for his suspension.
He was arrested.
That's
For
why.
commission,
Yes,
yes.
that's what I'm saying. He was arrested, so he was suspended. Then he
Yes.
was reinstated. Thereafter, any DP? Departmental inquiry.
No, my lord. Yes, there was a departmental inquiry,
Then, what happened?
and he was dismissed from service.
By which order?
19/2/2013. Annexure 4, page 64.
Dismissed from service.
Yes, my lord.
Then thereafter, he was convicted.
He was convicted.
No,
Actually,
he was already convicted in 2012.
yes, my lord. It was subsequent to the conviction that he was dismissed.
So are you challenging the dismissal or conviction?
No, only the claim for compassionate allowance. Compassionate allowance under the true provisions of the law.
You have not challenged your conviction.
No, my lord.
You have not challenged your dismissal,
No, my lord.
but you just want the compassionate allowance as well as the encashment of leave.
Yes, my lord.
Is that permissible?
That is permissible. There are several authorities which permits them, my lord.
So basically, your claim is restricted to that 2 points only.
Yes, only that 2 points. His
So-
conviction has already been decided in the appellate court as well.
How?
It was dismissed, my lord. And my lord, the affidavit in opposition filed by the state has highlighted the rejection of the claim for compassionate allowance.
Just a minute. Let me sum up your case. You are appointed in 1976 as LDC, Supply and Transport.
Yes.
Then you were made quasi-permanent. Thereafter, you were promoted to UDC and regularized in 1983. Then, because of your arrest, You were suspended from service but reinstated after 1 year. Ultimately, the trial ended against you. You were convicted.
Yes.
Following the conviction, you were dismissed from service after the panel proceeding was held.
Yes, my lord.
So you filed a criminal appeal from jail, isn't it?
In the conviction, my lord,
Against conviction, you file appeal.
that is prior to this petition, so I have no knowledge of that.
But you just said that it was
Yes,
rejected.
it was dismissed, my lord.
Ah, that's what. You file an appeal before this court, but it was rejected against your conviction. Today, your basic claim is for compassionate allowance as well as the encashment of leave,
Yes, my lord.
which according to you is permissible in law. Show me the authority.
I have submitted the bench.
Mahinder Dutt.
Mahinder Dutt, yes, my lord. There is one, and the just in the second page, my lord, there's a chronology of events which I have prepared. Uh, at the end, my lord, in 28 to 2006, after from the departmental actions in 1995 till the rejection of the claim by the tribunal in 2006, there's a chronology of events, and the findings of the court is in paragraph 12.
No, basically what we have to see now is that in spite of your conviction,
my
in spite of your dismissal from service, you are entitled to be given compassionate allowance.
My lord.
And also, you are entitled to encash your leave.
Yes.
So where is that finding here? You show me that.
Paragraph 12, my lord.
Yes.
Aggrieved with, may I read, my lord?
Yes.
Aggrieved with the order of the tribunal dated 28 to 2006, the appellant filed writ petition number 14924 of 2006 before the High Court. The High Court examined the submission on behalf of the appellant. It dismissed the claim of the appellant for compassionate allowance on the following consideration. Considering the aforesaid plea, we had directed the petitioner to file an additional affidavit to give particulars and details of the reasons which constrained him to avail leave without pay and to set out other special circumstances in support of his plea for compassionate allowance. The additional affidavit was not filed within 2 weeks as directed. However, further time was granted by us to the petitioner for filing the additional affidavit via order dated 11/10/2006. The additional affidavit that has been preferred by the petitioner, unfortunately, apart from mentioning in para 6 that the petitioner's condition was pathetic and his wife has suffered from cancer, and that he was apprehending amputation of his left leg below the knee, does not contain any averments with regard to the various bereavements suffered or the illness of his wife or the treatment thereof, and the respective deaths which came into the way of the petitioner from taking legal remedies. He has not brought forward any extenuating and special circumstances which had continued since then, which had prevented him.
Just a minute, just a minute. You get that CCS pension rules, not the compilation, you get the pension rules itself. Must be there in the library. Yes. You were
And
reading?
Para 13, I'll just
Yes.
jump to para 13.
Yes.
Madam. We are of the considered view that the adjudication by the courts below, with reference to Rule 41 of the Pension Rules 1972, is clearly misdirected. The rule itself contemplates payment of compassionate allowance to an employee who has been dismissed or removed from service. Under the punishment rules, the above punishments are of the severest magnitude. These punishments can be inflicted only for an act of extreme wrongdoing. It is on account of such wrongdoing that the employee concerned has already been subjected to the severest form of punishment, sometimes even for being incorrigible. Despite that, the rule contemplates sanction of a compassionate allowance of up to 2/3 of the pension or gratuity or both, which would have been drawn by the punished employee if he had retired on compassionate pension. The entire consideration up to the present juncture by the court below is directly or indirectly aimed at determining whether the delinquency committed by the appellant was sufficient and appropriate for the infliction of the punishment of dismissal from service. This determination is relevant for examining the veracity of the punishment order itself. That, however, is not the scope of exercise contemplated in the present consideration insofar as the determination of the admissibility of the benefits contemplated under Rule 41 of the Pension Rules 1972 is concerned. The same has to be by accepting that the delinquency committed by the punished employee was of a magnitude which is sufficient for the imposition of the more severe punishment. As in the present case, unauthorized and willful absence of the appellant for a period of 320 days has resulted in the passing of the order of dismissal from service. The punishment inflicted on the appellant has been found to be legitimate and genuine, as also commensurate to the delinquency of the appellant. The issue now is the evaluation of the claim of the punished employee under Rule 41 of the Pension Rules 1972. And basically, my lord, in this case,
Dika, both of you may go.
the Supreme Court has set 5 parameters which has to be considered in granting compassionate allowances. That is,
What is that?
starts from para 14.14.1, my lord.
You read from 14.
Yes, my lord. In our considered view, the determination of a claim based under Rule 41 of the Pension Rules 1972 will necessarily have to be sieved through an evaluation based on a series of distinct considerations, some of which are illustratively being expressed hereunder. Was the act of the delinquent, which resulted in the infliction of the punishment of dismissal or removal from service, an act of moral turpitude? An act of moral turpitude is an act which has an inherent quality of baseness, vileness, or depravity, which, with respect to a concerned person's duty towards another or to the society in general. In criminal law, the phrase is used generally to describe a conduct which is contrary to community standards of justice, honesty, and good morals. Any debauched, degenerate, or evil behavior would fall in this classification. 14.2 was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service, an act of dishonesty towards his employer. Such an action of dishonesty would emerge from a behavior which is untrustworthy, deceitful, and insincere, resulting in prejudice to the interests of the employer. This could emerge from an unscrupulous, untrustworthy, and crooked behavior which aims at cheating the employer. Such an act may or may not be aimed at personal gains. It may be aimed at benefiting a third party to the prejudice of the employer. 14.3 was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service, an act designed for personal gains from the employer. This would involve acts of corruption, fraud, or personal profiteering through impermissible means by misusing the responsibility bestowed in an employee by an employer, and would include acts of double dealing or racketeering or the like. Such an act may or may not be aimed at causing loss to the employer. The benefit of the delinquent could be at the peril and prejudice of a third party. 14.4 was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service, aimed at deliberately harming a third party interest. Situations hereunder would emerge out of acts of this service causing damage, loss, prejudice, or even anguish to third parties on account of misuse of the employee's authority to control, regulate, or administer activities of third parties. Actions of dealing with similar issues differently or in an iniquitous manner by adopting double standards or by foul play would fall in this category. 14.5 was the act of the delinquent which resulted in the infliction of the punishment of dismissal or removal from service, otherwise unacceptable for the conferment of benefits flowing out of Rule 41 of the Pension Rules 1972. Illustratively, any action which is considered as depraved, perverted, wicked, treacherous, or the like, as would this entitle an employee for such compassionate consideration. And my lord, I'll just continue with paragraph 15 as well. While evaluating the claim of a dismissed or removed from service employee for the grant of compassionate allowance, the rule postulates a window of hope if the case is deserving of special consideration. where the delinquency leading to punishment falls in one of the five classifications delineated in the foregoing paragraph, it would ordinarily disentitle an employee from such compassionate consideration. An employee who falls in any of the above five categories would therefore ordinarily not be a deserving employee for the grant of compassionate allowance. In a situation like this, the deserving special consideration will have to be momentous. It is not possible to effectively define the term special consideration used in Rule 41 of the pension rules. We shall not, therefore, not endeavor any attempt in the said direction. Circumstances deserving special consideration would ordinarily be unlimited, keeping in mind unlimited variability of human environment. But surely where the delinquency leveled and proved against the punished employee does not fall in the realm of misdemeanor illustratively categorized in the foregoing paragraph, it would be easier than otherwise to extend such benefit to the punished employee, of course, subject to availability of factors of compassionate consideration. Basically, my lord, what the Supreme Court had highlighted is that compassionate allowance, consideration of compassionate allowance under Rule 41 of the pension rules has to be in the light of these five parameters. And there are observations made by other high courts as well, which directed the state government to make an observation with regard to the points mentioned in this judgment. And the rejection was basically a denial, a blanket denial, and nothing was explained as to why the rejection, the compassionate allowance could not be given. Given the fact that he is a meritorious employee, given several certificates of appreciation by the concerned department wherein he was posted prior to his dismissal, and he was reinstated for his works.
Reinstated?
Subsequent to his suspension, my lord.
Okay, there is a different thing. You have Rule 41 with you?
Yes, my lord, I have.
The
Extracted in page 93 as well, my lord.
discretion is left on the authority, isn't it? It's not automatic.
Not automatic. It cannot, in fact, might not be possible to claim it as a right, but it has to be considered in the light of this judgment. Or in the
We'll come to the judgment later on. Let's see Rule 41 first.
My lord. Page 93, my lord,
Page 93. Which
of
page?
the petition.
You have abstracted it.
There is an extract, yes, my lord.
Okay, read.
Compassionate allowance. A government servant who is dismissed or removed from service shall forfeit his pension and gratuity, provided that the authority competent to dismiss or remove him from service may, if the case is deserving of special consideration, sanction a compassionate allowance not exceeding 2/3 of pension or gratuity or both, which would have been admissible to him if he had retired on compensation pension. A compassionate allowance sanctioned under the proviso to Sub-Rule 1 shall not be less than the amount of rupees 375 per mensem.
Just a minute. You're reading from which page?
Page 93 of the petition.
This writ petition is from jail.
Yes, my lord.
And you are the legal aid counsel.
Yes, my lord. The petitioner had drafted it himself.
He drafted himself.
Yes, my lord.
Page 93.
Page 93, annexure 29, sorry.
Page 29.
No, page 93, annexure 29.
The reason why I'm asking you about the page is that it is a bit slightly different from the book which I'm holding here.
My lord.
Page 93 is quite brief. This is Which edition is this? 2023 edition. And the one which you're referring to may be a slightly older version. See, you just read Supreme Court judgment. Based on the Supreme Court judgment, they have made they have incorporated some of the provisions in this new edition.
Yes, ma'am.
You're showing the old one, yet you're reading the Supreme Court judgment. You don't have this book with you?
I have
Read from the book. I think whether it's the same edition or not.
it's,
Page 105.
yes, it's page 105.
You just compare it with page 93, it's slightly different, isn't it?
Yes, the difference is the compassionate pension in the proviso in point 1, and in the book it's written superannuation pension. Here it's written compassionate compensation pension.
Then the second paragraph also,
Yes, my lord.
kind
there's
of very brief
Yes.
compared to the latest edition. You read the provision in the book,
Rule 41.
Rule
compassionate
21, Rule 41, Sub Rule 2.
Sub-rule 2. The competent authority shall, either on its own or after taking into consideration the representation of the government servant, if any, examine whether any compassionate allowance is to be granted and take a decision in this regard in accordance with the proviso to Sub-rule 1, not later than 3 months after the date of issue of the order imposing the penalty of dismissal or removal from service.
Okay, in your case, you were dismissed on 19/2/2013.
2013.
This has said that not later than 3 months. Anyway, number 3.
The competent authority shall consider A, which each case of dismissal and removal from service on its merit to decide whether the case deserves of special consideration for sanction of a compassionate allowance, and if so, the quantum thereof. The actual misconduct which occasioned the penalty of dismissal or removal from service, and the kind of service rendered by the government servant. In exceptional circumstances, factors like family members dependent on the government servant along with other relevant factors. Point 4. Where an order imposing the penalty of dismissal or removal from service was issued before the date of commencement of these rules, and the competent authority at that time did not examine or decide whether or not any compassionate allowance was to be granted in that case, the authority shall take a decision in this regard not later than 6 months from the date of commencement of these rules. No compassionate allowance shall be sanctioned after the expiry of the said period of 6 months to a government servant on whom a penalty of dismissal or removal from service was imposed before the date of commencement of these rules. A compassionate allowance sanctioned under the proviso to Sub-Rule 1 shall not be less than the amount of minimum pension under Rule 44.
So how does it apply to your case? It has set out a time limit of 6 months.
That is prior to the enforcement of these rules, my lord. If in case, this is 1972 rules, if in case I was dismissed in 1970, then within the application of this enforcement of this, within 6 months of the enforcement of this 1972 rules, my understanding is that it has to be decided within 6 months, subsequent to the enforcement of these rules.
So your case is after 1972.
After
There's no time limit.
No time limit, my lord.
Okay.
In fact, my lord, here in the Supreme Court judgment, which I had just stated, we could, Lordship may see that departmental action was initiated in 1995, and his claim for compassionate allowance came somewhere in 2002. That is after 7 years, my lord. And as per the affidavit in opposition filed by the state, in page 9 of the additional counter affidavit filed by the state, there's a letter dated 22/4/2013, wherein he has claimed for compassionate allowance, and that was rejected on 19/6/2013.
Where is the rejection? Let's see.
Page 9 of the counter affidavit filed by the state.
Any other rejection?
Yes, my lord. Annexure 2 as well.
Page?
Page 10. And Annexure 3 also.
Annexure 3.
There's a reference letter, my lord. In every rejection, there's a reference letter. In the Annexure 1, it's written 22/4/2013. That is the application made by the petitioner, which was rejected by this annexure. And the second application was on 25th June 2013. And the last was on 18/10/2021.
Three rejections.
3 rejections, yes.
Where is your letter? 22 April?
My lord, it's not on record, my lord. It's not on record.
None of these letters are on record.
No, my lord.
22/4/2013, 25/6/2013, 18/10/2021. Why is it not on record?
Maybe he must have misplaced it, my lord, since he's serving his time in jail.
This was drafted from jail.
Yes, my lord.
You have not drafted anything for him?
There's a rejoinder affidavit which I have drafted.
Rejoinder affidavit.
Yes, madam. Otherwise, the petitions and all are drafted by the petitioner himself. And my lord, may I take your lordship to the citation number 2, which I have submitted.
Just a minute. What all has he annexed in the writ petition?
Lordship has the index which I had submitted.
Yes.
The index. There's an index. Yes, my lord. And
These are documents
yes, the
which
list
he
of
has submitted.
documents.
And none of these documents pertains to his representation,
No, my lord.
starting from 22nd of April 2013.
Most of the documents are regarding the medical certificate
Okay, so fact remains that there is no document as such.
from service on account of the aforesaid conviction,
What is 325?
causing grievous harm.
Earlier conviction was under 302.
302, my lord.
On his appeal,
On his
it
appeal,
was converted into 325.
yes, my lord.
By the appellate court or by the trial court? By the appellate court, perhaps.
By the appellate court.
Then,
He was, I'll continue, my lord.
Yes.
He was, however, removed from service on account of the aforesaid conviction. Therefore, merely because the petitioner, since deceased, was removed from service for the aforesaid misconduct, that alone would not furnish a ground to deny him the benefit of compassionate pension. On going through the return filed on behalf of the respondents, we find that the only reason assigned for rejection of representation for compassionate pension was that the petitioner was convicted for offense under Section 325 of the Indian Penal Code, which was considered to be serious offense. In our considered opinion, in terms of provisions of Rule 101, the respondents ought to have considered the representation of the petitioner from a point of view if the case is deserving of a special consideration for grant of compassionate pension independently. Since that has not been done and nothing is on record adverse to the interest of the petitioner since deceased for grant of compassionate pension, we find that the impugned order suffers from legal infirmity, namely non-application of mind. That necessarily follows that the impugned order deserves to be set aside. In the facts and circumstances of the case discussed above, we find that the petitioner was entitled to compassionate pension. It is admitted position that the petitioner is now dead. The legal heir of the petitioner has been brought on record. The petitioner is survived by his widow only, who is aged 74 years. We therefore feel that the respondents can be directed to grant family pension to the widow of the petitioner since deceased. In the result, we allow the petition. We set aside the impugned order and direct the respondents to pay arrears of compassionate pension due to the petitioner since deceased and further grant family pension to his widow. The payment should be made within a period of 3 months from the date of receipt of the writ. Rule is accordingly made absolute. There shall be no order as to cost.
So petitioner died,
He died.
but the court said that it should, widow is still alive,
Yes, my lord.
so family pension should be given to the widow.
Yes, my lord. The widow is entitled to the claim. And that observation was made by the Delhi High Court as well in a very recent judgment, which I have which
But we are talking about compassionate allowance,
compassionate allowance, man.
but here the court has granted family pension instead.
And compassionate allowance as well, my lord. The impugned order and directed the respondents to pay arrears of compassionate pension due to the petitioner and further grant family pension to his widow.
You said you have the rules with you. They're talking about Rule 101.
That is Maharashtra.
Ah, correct.
Yes, my lord.
What is that?
I have an extract if lordship would
Just read 101. What does
101.
it say?
Grant of compensation pension in deserving cases by government. When a government servant is removed or required to retire from government service for misconduct or insolvency, or is removed or required to retire from government service on grounds of inefficiency before he is eligible for a retiring or superannuation pension, government may, if the case is considered deserving of special treatment, sanction the grant to him of a compassionate pension.
So it's something like Rule 41.
Yes, a similar provision, my lord.
See, you have shown me the rejection of your application.
My lord.
One single communication is rejected. Any other thing, anything else has been given? Why it was rejected, how it was rejected?
No reason has been accorded.
No reason. No reason.
No. Not in the light of the 2014 judgment and nothing else. Just a complete rejection. Likewise, which was observed by the Maharashtra High Court, Bombay High Court. It suffers from legal infirmity, non-application of mine.
Then what about the other remaining judgments which you are relying upon?
In the third judgment, my lord, that is rendered by the Delhi High Court, wherein the petitioner was a constable and he had accepted an illegal gratification and extorted rupees 1,000 from Udan Singh. So
Then he was granted. Was he granted?
yes, he was granted.
But the first judgment which you read speaks about some illegal gratification and all that. Does it not debar?
The first judgment is regarding unauthorized absence for 320 days. The offense is 320
No,
days of
that
absence.
Mahinder Dutt's case.
Yes, in Mahindra Dutt's case, 320 days of absence.
No, that is 320 days of absence. But the thing is that the Supreme Court has laid down the parameters under which these things are to be considered.
Yes,
At paragraph 14. 14.1 to 14.5. 14.3 speaks about corruption,
corruption. Yes.
fraud or personal profiteering through impermissible means. So, if you are found to be indulging in such kind of actions, then this compassionate allowance can be denied to you.
Yes, my lord.
But you're coming up with a judgment which saying that this guy was getting illegal gratification of rupees 1,000 from somebody.
Yes, my lord. In 2000
Nevertheless, he was still given compassion allowance.
and
Does it not go against this Mahinder Dutt's case?
My lord, para 15 would come into play as well. If-
15 of Mahinder Dutt,
Yes, 15 of Mahindra.
what does it say?
While evaluating the claim of a dismissed or removed from service employee for grant of compassionate allowance, the rule postulates a window of hope if the case is deserving of special consideration, where the delinquency leading to punishment falls in one of the 5 classifications delineated in the foregoing paragraph. It would ordinarily disentitle an employee from such compassionate consideration. An employee who falls in any of the above 5 categories would therefore ordinarily not be a deserving employee for grant of compassionate allowance. In a situation like this, the deserving special consideration will have to be momentous. It is not possible to define the term deserving special consideration used in Rule 41 of the pension rules. We shall therefore not endeavor any attempt in the said direction. Circumstances deserving special consideration would ordinarily be unlimited, keeping in mind unlimited variability of human environment. But surely where the delinquency level and proof against the punished employee does not fall in the realm of misdemeanor illustratively categorized in the foregoing paragraph, it would be easier than otherwise to extend such benefit to the punished employee, of course, subject to availability of factors of compassionate consideration.
So here it says when the delinquency leading to the punishment falls in one of the 5 classifications, 4.1 to 4.5, 5 classifications, it would ordinarily disentitle an employee from such compassionate consideration. So you had just read about that illegal gratification of accepting bribe of rupees 1,000. Will it not come under 14.3?
That was rendered in, this decision was rendered in 2008, my lord, prior to the 2014.
Okay, prior to that.
Yes, my lord. And
So
the-
2014 is relevant then? Why do we have to go to 2008 then?
But the observation made herein is relevant, my lord, in considering that claim. Para 7, my lord, if I would, may I take your lordship to para 7 of the Delhi judgment, the 3rd citation.
This one, ex-SR Shadiram. Is this the one?
Yes, yes. Para 7.
Yes.
May I read, my lord?
7, yes.
I am in agreement with the finding that for the purposes of considering grant of compassionate allowance, entire service record needs to be considered, and an isolated incident of misconduct, however grave, cannot be determinative of the issue, even though dishonesty in service is a significant and relevant factor to be considered among others, such as financial and personal circumstances of the concerned employee.
Okay, so what you mean is that one isolated case of some dishonesty leading to the conviction and all that cannot be the sole ground. The entire service record has to be looked into.
Exactly, my lord.
This is what you're
Yes.
stressing upon. Okay. Now, again, coming back to that Mahinder Dutt's case. There's also something mentioned about conduct 14.1. Conduct which is contrary to community standards of justice, honesty, and good moral. You could not give a more legible one, is it? Degenerate or evil behavior would fall in this classification. Will you not fall under 14.1? You have been accused of 4302. Not only accused, but you have been convicted.
Convicted, my lord. But likewise, as I have mentioned, my lord, para 15 would be the saving clause in that regard, because there's a window of hope, and the rejection by the authorities has not been considered in the light of this judgment as well.
The rejection has not been substantiated. That
Exactly.
these are the parameters under which we have considered your representation, but we cannot give you.
My lord,
Nothing of that sort.
nothing,
They just say that it's rejected.
my lord.
So going by the authority you have produced, if court agrees with you, then it would be the prerogative of the government to look into this under the parameters given.
Exactly, my lord. Given the
We cannot determine at this stage that you should be given or you should not be given.
given the fact that he was a meritorious employee and given a letter of appreciation by the concerned departments, which is in annexure 10 to 14. His service records, that adds to his service records, my lord. That ought to be considered. And
What
there
is what is your service record?
he has mentioned that he was not given anything below very good in his SER. The relevant portion is that para 8 and 9. And here also, my lord, Mahinder Dutt was observed as well. High Court of Kerala, yes. Paragraph 8, my lord. There's a shaded area, if lordship would see. I'll read, my lord. Here also, the petitioner was dismissed from service for unauthorized absence, which does not fall under any of the illustrations in Mahinder Dutt Sharma. The petitioner's wife and children being employed cannot by itself lead to the conclusion that the petitioner's case does not deserve special consideration. In this regard, the following observations in Exhibit in Exhibit R2B report of assessment assumes relevance. And accordingly, my lord, the writ petition was allowed and compassionate allowance was granted today, was ordered to be granted within 2 months of receipt of the copy of the judgment. My lord, yes, my lord. If at all the submission is considered not sufficient, my lord, there is at page 94 of the petition, wherein an MCS officer, Mr. L. Rinsang Akolni, who was convicted for under the PC Act, was granted compassionate allowance.
94.
Page 94, annexure 30. Parity could be claimed in that regard, my lord, and as well as in 31, page annexure 31, the next page. Here also, leave encashment of unutilized earned leave was granted to a police personnel who was convicted under POCSO Act, my lord.
Page 31.
Annexure 31.
It's hardly legible.
Hardly legible, my lord.
Leave encashment granted to a police personnel
Yes.
convicted under POCSO.
Yes, my lord. And in my rejoinder affidavit as well, I have annexed.
Why don't you have a more legible copy? We can't read at all. What is written here? We don't know.
My lord, like I said, like I've mentioned, it came from jail, so it has-
Maybe, but you are here to assist, so you should have got it typed.
my lord.
Where's the explanation to 31? Page 41.
Annexure 31, my lord.
Annexure 31 we cannot read.
My lord.
So at least the statements against 31 made at page 41, let us read that.
Yes, my lord. That due to I have been facing unbearable financial hardship for the duration of my imprisonment to support my medical treatment and medication of different illnesses I face too. I therefore earnestly would like to request you to kindly consider my humble writ petition and to take necessary steps with the competent authority to grant me a compassionate allowance not exceeding 2/3 both of pension and gratuity as admissible under the Rule 40, so to grant me encashment of my 300 days unutilized earned leave, which accumulated since 10 years back of my dismissal from service, as in the case of Havildar L.R. Muana, 3rd Battalion MAP, as admissible under Rule 39, 6A, subclause 1 of CCS leave rules.
He has not substantiated. He has just said that one Havildar L.R. Mona was given.
My lord.
I should also be given.
My lord.
What was given to him was leave encashment.
Leave encashment, my lord. And if you may I take your lordship to the rejoinder affidavit which I have filed. There I have annexed the pensionary benefits which was granted to Mr. C. Lianpuya, who was convicted under POCSO Act, and till date he is serving his time in jail. And page 10 of the affidavit, my lord, there it states the certain benefits that was granted, and leave encashment of 10 lakhs 32,240 was also granted. Likewise, in the case of Mr. Kelal Monkima, he is also convicted under POCSO Act, and all the benefits have been conferred, my lord.
Annexure 1, isn't it? Of your rejoinder.
Yes, my lord, Annexure 1.
Then, what is Annexure 2 and 3?
Annexure 2 is regarding, Annexure 1 is the dismissal order, my lord. Major penalty of compulsory retirement was given, and Annexure 2 is the pensionary benefits given to Mr. Sila Lianpuya. And Annexure 3 is the retirement benefits to other personnel named Mr. Kelal Monkima.
What was this case?
POCSO Act.
Kelal Monkim also.
POCSO Act, yes, madam.
Where is it given?
His termination order is not annexed, my lord.
So how do you say that he was convicted under the POCSO?
I have made an RTI application, my lord, and additionally I have stated required for any person who was dismissed likewise in the case of Mr. Sil Lempuya, and they have given me this document, Annexure 3. Both are high school teachers, madam.
There's no counter affidavit against this rejoinder?
No, madam.
So let me hear Miss Linda then. What is this bunch of criminal appeal 13 which you have given?
No, that is not my case, madam.
Silal Thiangtima.
That must be the order.
It's an order, yeah. Why is it available here in this file?
I have not provided, my lord.
What's the name of the appellant?
Sila Thiangtima.
Okay, that's why. Okay. Yes, Ms. Linda?
Yes, Your Lordship, we have filed our affidavit wherein we have mentioned that we have received applications from the present applicants thrice.
Thrice.
And it was rejected 3 times.
On what ground?
The grounds which the grounds is not mentioned in the rejection order. However, my lord, the reading of this pension rules, CCS pension rules 41, it has given wide powers to the authority, to the competent authority, to decide whether the applicant is deserving of special consideration.
So how do we appreciate whether you have exercised that wide authority? You just written one simple line that rejected, that's all.
Yes, my lord, because
Since the petitioner is before the court, just mentioning you rejected will not do. You'll have to explain how you are rejected. What were the reasons behind? That is not available.
mentioned, yes,
That's
that
not
is
mentioned.
However, my lord, what we'd like to point out is that it cannot be claimed as a matter of right. The only reason he can claim is if he is of a deserving, he's deserving the such consideration. However, my lord, in his case, he has been convicted of cold-blooded murder. So the department has not found any special consideration in his case. And that is why they have simply rejected it.
Simply rejected will not do. We have just seen, you have also seen the parameters under which the court, the authorities, has got wide powers. They may reject it, but they must give a reasons. We have examined everything, but we find that he's not deserving, something like that. Now simply they have just rejected 3 times. So we don't know under what was the consideration before them. Would you like to produce the records, or what is to be done? Or we direct the respondent authorities to consider?
I'm not, I don't think, my lord, they have mentioned any reason.
That's
But
what.
let's see if they have mentioned anything. I can produce the records.
Get the records,
Hmm.
if there's any. But I'll give you just 2 days time for that. We'll have it on Thursday again.
All right.
If anything is given, give the records, you get the file. What were the parameters under which the examination was done? If it was done, let us see. If not, we'll have to consider.
Mr. Lordship, I'll first produce the records, if anything is written. Then maybe we can have a
Please call
hearing.
the stenos. Because in the judgments which have been produced by the Legal Aid Council, see, in some cases such consideration was not done. In some cases it was done, but the court said that, see, this can't be the consideration, and that's why they interfered with. So, but in the present case, it's basically just reject, that's all. So what transpired while considering their application is not available. At least that thing should be available to the court.
That we have mentioned only in our affidavit. Yes.
This writ petition is filed from jail. And Mr. Tlantiang Thema is the legal aid counsel. I'm sorry, Mr. Lalrokuma Pautu is the legal aid counsel. He submits that by filing this writ petition, the petitioner claims for compassionate allowance admissible under Rule 41 of the CCS Pension Rules 1972, and for encashment of unutilized leave under Rule 39, bracket 6, bracket small a, bracket small Roman 1 of the CCS Leave Rules 1972. The learned counsel submits that Although the petitioner may have been convicted under 302 of the IPC, but he is entitled to receive the above benefits. Stop. In support of his claim, the learned counsel has relied upon the following authorities. Number one, Mahinder Dutt Sharma versus Union of India and others. 2014-11 SCC 684. Number two, Anna Dioram Lodh deceased through his LR, Srimati Indra Bhai and Anna Lodh.
Obliged.
Item 4.
My lord, in this matter, pleadings have been completed and matter may be fixed for admission hearing, my lord. Miss Mary, my lord. My lord, if possible, next week. She, my lord, Miss Mary is absent, my lord. She has some personal difficulty, that's why.
So you should say that it should be heard ex parte. Why are you bothered about Mary? Problem is that you mentioned for the other side. The other side will mention for you also. This brotherhood, sisterhood should not be there.
Yes, ma'am.
And so far as cases are concerned.
Miss Mary is handling this case. However, she is on legs in the other courtroom. And she told me that this matter can be listed for hearing, for admission hearing, as pleadings are completed.
That is what we just said just now.
Yes, my lord.
What is it listed for today? Why is it listed? Tell me.
For admission, my lord, the
Huh?
file is not with me.
So what is the fun of listing again and again for admission hearing when it is listed for admission today itself?
Yes, my lord.
List again after 2 weeks.
Item 5.
My lord, I seek 2 weeks' time to file my counter affidavit for the respondent number 5, my lord.
As prayed for by Mr. Sitlan Thianglima, learned counsel for the respondent number 5. Further 2 weeks' time is granted for filing counter affidavit. List
Obliged.
again after 2 weeks. Mr. Roshan Subedi, learned counsel, appears for the petitioner.
Item 6.
I may be allowed to withdraw with liberty, my lord, this petition.
As prayed for by Mr. Victor L. Ralte, learned counsel for the petitioners, the writ petition stands dismissed as withdrawn with liberty to file afresh, if so advised.
Much obliged.
Item 7.
Lordship, I am appearing for the respondent 1, 2, and 9. And I will be filing my affidavit in opposition within this week.
Okay. Miss Caroline K. Lungorpui, learned government advocate, appearing for respondent numbers 1, 2, and 9, submits that she will be filing the counter affidavit of the respondent she represents within the course of this week.
behalf of respondent 5 to 8, we are yet to file, however, have not yet received it. Comments.
Stop.
May pray for 2 weeks.
Mr. Samuel Bounty, the Changte learned counsel for respondent numbers 5 to 8, submits that he is yet to receive instructions in the matter and prays for 2 weeks' time. In view of above, matter stands adjourned for 2 weeks.
Lordship, Mayor, Lordship, the other similar matters, there are so many similar matters. This is a JICA matrix, Lordship, are pending for disposal. So it may be clubbed together along with the others writ petition. One is 7 of 2024.
In view of above, you cancel that, okay? Next para, at this stage, Mr. Johnny L. Tochong, learned counsel for the petitioners, submits that the instant case may be clubbed together with similar other matters which are pending before this court. That is WPC number
7 of 2024.
7 of 2024, which is one of those cases. In view of above, registry to list the matter along with WPC number so and so.
Much obliged, Lordship.
Respondents to file their counter affidavit in the meantime.
Item 8.
Yes, what is this item 8?
The respondent are yet to file their affidavit in opposition.
Then what is this? Entire, this thick file?
This is a
This
case.
is without any affidavit. Only writ petition.
Yes, this is the writ petition is filed second round litigation. This is a second round of litigation. The earlier writ petition was disposed of, and then a decision was taken by the CADC.
This
and
entire
then
bunch is just writ petition.
Yes, Your Lordship.
I thought this is complete. Everything is complete. Not yet
This is
complete.
including the previous writ also. So
What is your claim?
claim is the salary of the some of the employees of the CADC. They have approached this honorable court earlier in one of the writ petition, and then that writ petition has been disposed of, directing the CADC to take a call. And the CADC has taken their own call, and then this is the second round of litigation, being aggrieved by one of the order passed by the CADC. They are before this court again.
You have not got the relief.
No.
You have challenged that order.
Yes.
Rejecting your claim.
Correct. Yes.
Okay. And who appears for the CADC?
CADC 123 is Lalsan Liana Kyangte, and the respondent number 4 is the district minority and all, represented by Miss Nal Louis. She has, in fact, told me this morning that she is going to seek some more time in filing affidavit.
And Mr. Lalsan Liana? His file is Vakalandama?
Yes, his name is also reflected.
Where is he?
I was just trying to contact him, but I could not reach him.
He was here this morning.
Yes.
Doing his motion matter.
I've sent a message to him, but he has not
He
replied.
got the order in the motion matter and left.
Probably. He has not
Enough for
given-
the day. No? As prayed for by the learned counsels for the respondents, further 3 weeks time is granted to file their counter affidavit. List again after 3 weeks. Please inform them.
I will. I'm obliged.
I'll rise for 5 minutes and come back.
Hearing item 11.
Wait, please, Your Lordship.
Yes.
This is an appeal under Section 37 of the Arbitration Conciliation Act 1996. Your Lordship, at the outset, before we go into the merits of the case, there's some difficulty. The paper book does not include the pleadings before the arbitrator. Although we had annexed the same in my appeal memorandum, the paper book has been prepared by the authorities concerned by the office without including the pleadings which were submitted before the arbitrator. And the arbitrator's records were not called for. So whether the records are required.
What was the proceeding before the arbitrator?
Yeah,
Did it involve any examination of any?
Yes, Your Lordship, the documents were exhibited before the arbitrator. And the main dispute, Your Lordship, is regarding maintenance fees, service and maintenance fees. According to the appellant association, shop owners association, although the maintenance fees can be imposed upon the shop owners, but it has to be on the basis of the actual maintenance expenditure, and it cannot be arbitrary. So that was, in fact, the grievance of the shop owners. They approached the Millennium Center for appointment of an arbitrator, which was rejected. So they approached this Honorable Court. This Honorable Court passed an order for appointment of the arbitrator. In fact, this Honorable Court appointed the arbitrator. The arbitrator thereafter took up the matter, and after hearing both sides, came to the conclusion that the imposition of the maintenance fees at the rate of 7.5% per annum with effect from 2020 was arbitrary. And the arbitrator modified the imposition of the maintenance fees and the toilet usage fees. Thereafter, the Millennium Center Authority had preferred an application under Section 34 before the district judge, and that was allowed. The arbitrator's award was set aside, and now the shop owners are before your Honorable Court, Your Lordship.
You have challenged the order under Section 34.
Yes. So now the paper book does not include the pleadings before the arbitrator. And we will have to refer to the pleadings of the arbitrator, because before the arbitrator, the case of the Millennium Authority, the respondents, was that the imposition of maintenance costs was justified. They stated that because of the different heads, so the maintenance fees imposed by them was justified. It was not the case that the imposition of maintenance costs was beyond the contract agreement, beyond the lease agreement, and it could not be referred to arbitration. Subsequently, when the arbitrator passed his award, they filed the application under Section 34, and in that they have taken the stand that the grievance of the petitioners was not within the agreement clause.
Okay, the appeal preferred by the authority.
Yes.
That is available in the paper.
That is available.
Okay, but the pleadings before the arbitrator
is not available.
And pleadings means both sides or only one side?
Both sides.
Then where will the record be now?
Judge, I have annexed them in my appeal. It's available in the writ appeal, but it was not included in the paper book. So unless it is included, then it may cause some inconvenience, because we are.
No, you were also talking about the records.
Records are available with the arbitrator. Whether your Lordship would like to look into the records, if your Lordship feels that the records will be needed, then.
No, if it's needed, then we call it. If it's not needed, why should we call it?
My learned senior friend is also there.
On the request of the learned friend, my lord, in last page of the paper book, my lord, it was not called for earlier, my lord. So direction was given to prepare a paper book. Accordingly, paper book is prepared, my lord. But due to non-calling of the lower court record, the registry probably does
not
not
call it.
include that pleading, my lord. Last page, my lord.
Last page of?
Paper book.
Paper book, my
Paper.
lord.
So, will it cause any difficulty if we refer to both a paper book and one side the memo of appeal for the?
But memo of appeal, I think memo of appeal is there,
Yes, ma'am.
but annexes are not there, I think.
I'm not sure. No.
Annexes are not there. Because in the 34 petition, arbitrator record was called for. That is why it was not annexed there.
Okay. Your Worship, then the pleadings before the arbitrator, which have annexed in the appeal, they may be included in the paper book.
Where's the page, starting from page number?
In my writ appeal, in my appeal under section 37, at page 57, annexure 6. This is the petition filed before the arbitrator by the Shop Owners Association.
57.
Page 57. And at page 77 is the written submission made by the Millennium Center Authority before the arbitrator.
57, it starts from 57 up to which page?
76.
Pleadings.
76.
76?
Yes.
No, excluding the pleadings of the authority.
Yes. 57 to 76.
Then 77 onwards is the reply.
Yes, 77 up to 88.
Then 89 onwards is the judgment.
89 was the judgment.
So parties may decide what to do. You want the records to be called, or we'll rely upon these 57 to page 89, 88.
I'll leave it to my learned senior friend. He's
Yes.
come from God.
Whether your petition is paper book or not.
It's not in the paper.
Not paper book.
Not in the paper.
It is not in the paper book, my lord.
That's what.
There is.
So
You
it is
can
not in the
furnish-
paper book, but it's in the memo of appeal. So it is to take out from the memo of appeal and you can paste it to the paper book.
In memo of appeal, this memo of appeal also not here, my lord, in paper book. In paper book also that document is not available.
Yes.
No, that is why
Yes,
we take out the relevant pages from the memo of appeal
yes.
and get it pasted in the paper book. That is one way.
Okay, my lord.
That is one way.
Yes.
The other way is that if you want the records to be called and take out from the original records and keep it in the paper book.
Not necessary, my lord, because the document is available both sides.
Okay, then.
I'll leave it up to my.
Mr. I.R. Malhotra, learned counsel, appears for the appellant, while Mr.
Yes,
P.S. Dekha, learned senior counsel, assisted by Mr. Sridhar Pajwala, appears for the respondent. Respondents.
yes, my lord. Respond.
So it is mentioned by the learned counsels for the parties that the pleadings before the arbitrator by the appellant as well as by the respondents is not available in the paper book, and therefore the same may be incorporated. for the sake of convenience to all the parties concerned. Stop being stated herein that it was at the submission made by the learned counsel for the appellant that the original records was not called from the arbitrator. But at the same time, it is seen that the pleadings made by the parties before the arbitrator is available in the memorandum of appeal, starting from, no, full stop, huh? Not starting from, you cancel, full stop. The application submitted by the appellant is from page 57 to page 76 of the paper book.
No, of the appeal memorandum.
I'm sorry, of the memorandum of appeal. While the written reply made by the respondents are from page number 77 to page 88 of the memorandum of appeal. Stop. Such being the position, comma, the registry shall incorporate the application submitted by the appellant and the reply submitted by the respondents in the paper book. The parties shall submit their respective paper book before the registry within the course of the day.
Yes.
And whereafter the registry shall do the needful. When do we list it?
Or my lord, may please not.
Yes.
Or it is maybe part 2, paper book part 2, or that we not necessary to return back.
Okay. I think that's a good idea also.
Yes, madam.
Then what did I say last? In view of above? Before that, what did I say? No. Before that, what sentence? What is sentence? Full stop. Okay, the rest you cut. Not required. Next para. In view of above, the registry shall prepare a part 2 paper book comprising of the application submitted by the appellant and the reply submitted by the respondents as stated herein above, and furnish the same to the parties concerned. Stop. Such exercise be completed within a week from today. List this matter again.
At the cost of the appellant.
At the cost of the appellants. You'll have to deposit something.
Yeah.
You have to deposit, yes. Yes. Shall prepare accordingly at the cost of the appellants, okay? Appellant. As grateful, let the matter be listed again on
In June, 6 June, it is possible, if possible, my lord.
6th June.
Meantime, they will furnish, the registry will furnish the,
You want it on Friday? 6th June is Friday.
yes. Friday.
Make it 5th.
Okay, everybody.
5th June.
If just in case the case
Yes.
spills over,
Yes,
then
yes.
you have
Then
better chances.
We can take chance, my lord.
5th of June.
List on 5th of June, 2025, as paid for.
Item 12.
Yes, item 12. What is this matter? Yes, miss, what is this matter?
So in the hearing held in 24th March, your lordship recused yourself from the case. However, the case has been put up in your bench again.
What is that? Oh, that.
Lock
Lok
Adalat.
Adalat. But there's no such order passed, isn't it?
No, your,
There's an order
no, my
dated
lord.
first.
Huh? No such order passed, although I recused.
No, my lord. It was not there. No order was written.
Okay. So we'll pass the order now today. List this matter before any other bench and not before me. Within bracket, my name.
Oh,